In this video, we're going to discuss the Corporate Transparency Act. I'll cover why the law exists, who needs to file, what you must file, what information you must disclose, and the penalties for not disclosing. Also, at the end, I'll discuss how a court case could make all of this a moot point. First, what is the Corporate Transparency Act? Congress passed the Corporate Transparency Act in 2021. The new law requires you to disclose beneficial owner information, or otherwise known as BOI. The intent of the law is to catch criminals who launder money and hide behind shell corporations, according to Congress.
With the CTA, Congress intended to enhance our national security by preventing bad actors like China, Russia, and Iran from using the financial system for illicit purposes.
This may be true, but 32 million U.S. business owners must file this information also. And we all know that criminals will be filing theirs too. The information you must report is going to be filed with the United States Treasury Financial Crimes Enforcement Network, otherwise known as FinCEN. If you remember the movie The Accountant, J.K. Simmons played a FinCEN agent. He was chasing Ben Affleck, the accountant who helped criminals hide their info using offshore accounts and shell companies, kind of what this law is trying to prevent. FinCEN requires any company they consider a reporting company to file information through their website. So what's considered a reporting company? A reporting company is any U.S.-based entity, including partnerships, corporations, LLCs, and other entities formed under state law. This also includes foreign companies registered to do business in the United States with any state. The good news is there are 23 different exceptions to the rule. The bad news is the vast majority of small business owners will not fall under the exceptions. Most exemptions will apply to companies already regulated by the government, like the SEC. For example, public companies, banks, insurance companies, investment advisors, and venture capital funds. So, what exemptions could a small business actually qualify for? First, a small business may qualify for an exemption known as a large operating company. To qualify as a large operating company, you must first employ 20 full-time employees in the United States, have an operating residence at a physical office within the United States, earn over $5 million in gross receipts or sales in the prior year, and file a federal tax return reporting more than $5 million in sales. The second exemption applies to inactive entities. This would include entities that existed before January 1st, 2020, have not engaged in any business activity, they're not owned by any foreign person directly or indirectly, has not changed ownership in the past 12 months, has not sent or received any funds greater than $1,000, or sold any assets or ownership in the entity. I've included a link below to give you a list of the exceptions and all the different details to determine whether you qualify. Now, let's discuss what we must disclose. The Transparency Act requires you to disclose information about the company and beneficial owners. A beneficial owner is anyone with substantial control of a reporting company and anyone who owns or controls at least 25%. Then there's the question, what's considered substantial control? A person exercising substantial control will fit into one of four categories typically. First, the individual is a senior officer. Second, the individual can appoint or remove certain officers or a majority of the reporting company's directors. Third, the individual is an important decision maker. Fourth, the individual has any form of substantial control over the company. This is a very broad area, so make sure you consult with an attorney if you have to in order to determine who has substantial control. Examples of this may include the CEO, CFO, COO, an LLC's manager, or a partnership's general partner. Ownership of at least 25% will include individuals who own equity, stock, voting rights of a corporation, a capital or profit interest in an LLC or partnership, convertible debt, options or other non-binding privileges to buy, sell any of the options, or any other binding right to buy or sell any stock, capital, or convertible interests, and any other instrument, contract, or other mechanism used to establish ownership. Basically, they don't want you to go out and create a whole bunch of documents that hide the ownership inside some rights to buy, I can buy, I could control, things of that nature, which I'm sure no criminals will do. Next, what information do you have to disclose? This is going to include the name of the company, the principal business address in the United States, Any other trade names or DBAs doing business as, jurisdiction of formation, basically the state where the company is registered, the IRS issued EIN number, and the company applicant. So what's the company applicant? This is usually the person who filed the information in order to create the entity. This could be a corporate service, a lawyer, or yourself. One thing to note here is that this information only needs to be reported on entities that were formed after January 1st, 2024. Next, for beneficial owners, you're going to have to disclose the following: legal name, date of birth, residential address, an identifying number from a driver's license or passport. This will have to be uploaded as part of the documentation into their system. A common question is whether you need to file a report annually. The answer is no. But there's a catch. If you have any changes to your company or beneficial owner information, you must update that report within 30 days of the change. And if you realize your report is inaccurate for any reason, you must also make that correction within 30 days of discovering the error. So let's talk about penalties. What if you decide not to file? You don't want to comply. Yeah, you created that entity in Wyoming where they don't disclose any information, but that's Wyoming, that's not the federal government. So consequences can be severe. Fines of $500 per day, up to $10,000, and possibly 2 years in jail. They say that anyone that willfully provides or tries to provide false or fraudulent information or fails to report complete or updated beneficial ownership information is liable. Now, the important term here is willful. Willful is the voluntary intentional violation of a known legal duty.
We're not in the business of playing gotcha when it comes to enforcement. The statute is very clear. We can only take willful action we can only take enforcement action against willful violations. And this is not about punishing small business, but looking for those actors that are willfully evading the requirements.
But as somebody who's worked with the government on different filings for over 25 years, their definition of willful and yours may be different. So just file the document. At the beginning, I told you about a court case that could make all of this information irrelevant. The court case is with the National Association of Business Owners versus Janet Yelling. Basically, this group sued the U.S. government stating that this law is unconstitutional. And the judge agreed. FinCEN did agree to stop enforcing the rule, but there's a catch, like everything else. This is only going to apply to those businesses that were a part of the association, which in reality makes up a very small percentage of businesses. This does not apply to everybody else unless you're part of the court case. But who knows? Things could change and this could all go away. So how do you file? Starting January 1st, 2004, you can file online. I'll provide a link below in the description to where you can go to file. You'll basically need to create a login and then go through and answer all the questions and information that we've already discussed in the video. So that's it. Corporate Transparency Act. Hope this video clarifies your obligations under this new law. If you have any questions, please leave them in the comments below. Thanks.